Good morning, everyone, and welcome to a CER Action Series special event on the implications of Espinoza. Fabulous fabulous for us, that is. Let me just put that out there. That might not be everyone out there who thinks it's fabulous, but Espinoza versus Montana Department of Revenue was decided by the Supreme Court last Tuesday, June 30th. And in a few minutes, we are going to jump into a discussion with the two attorneys who help represent our amicus brief, our friend of the court brief at the Center for Education Reform on behalf of a number of leading parent and groups. I am so pleased that we have with us two remarkable people, and I'm going to introduce them in just a few minutes. But first, I want to thank all of you for joining us. We have a fantastic, really interesting, diverse group of leaders in education, private, public, and charter, foundations, media, and some skeptics as well. So we hope to get into a Q&A with all of you. Very important that you know we are not using the chat. We are using the Q&A function. And as we can, we will take your questions during the event, but otherwise we will make sure that we cover you at the end of the event. This is being recorded. It will be posted as well. And this will not be the last. This is in fact the 10th of CER's Action Series events. So first, let me go ahead and introduce our two guests for today. Paul Clement, the 43rd Solicitor General of the US during the Bush administration, who also served as Acting Attorney General from 2007 to 2008. Mr. Clement's currently a partner at Kirkland and Ellis, and he has argued over 100 cases before the US Supreme Court. He is also a senior fellow at the Supreme Court Institute at Georgetown University, has represented CER multiple times in amicus brief, and his brief was cited multiple times in the Espinoza versus Montana decision. George Hicks is a partner at Kirkland and Ellis, also an associate and a partner at Kirkland and Ellis, selected to super lawyers in 2020, and a top-rated appellate attorney as well. George has also argued successfully before the Supreme Court numerous times and was a law clerk to Justice John Roberts. So welcome, George and Paul. I feel like we're having the Beatles. We might as well play the band. I know I'm going to get really schmaltzy in all of my analogies today. Hi, Paul. How are you?
Doing great. Great to be with you.
Hey, George. How are you?
Good morning. Great. How are you all?
Fantastic. Thanks so much for taking the time to join us today. So let me go ahead and just start with a couple of quick opening general cues. So first, do you think this was a long time coming? And Paul, if you could kind of define what the this is for the neophytes in our audience, that would be great.
Sure. I mean, I'll kick it off. I mean, I do think this decision was a long time coming. And I think, in thinking about what the this is, it's really a recognition by the Supreme Court that the states cannot, in general, and there may be some limitations and we can talk about that, but in general, the states can't use their state Blaine amendments to essentially impose a higher wall of separation of church and state than the federal Constitution if, in doing so, they end up discriminating against religion. And this case is a perfect illustration of that, because you had a situation where the state of Montana was using its state Blaine amendment, and it was using it in a way to say, at least initially in terms of the state authorities, that you can't use these funds at a religious school. You could use them at a different school, but not at a religious school. And the justification for it was Montana's so-called no aid clause. And so the court said, no, that doesn't work. You can't put the state no aid clause essentially and give that more prominence than the federal free exercise guarantee. The federal free exercise guarantee critically gives you a guarantee of equal treatment, non-discrimination on the basis of religion. And so as a result, Kendra Espinoza and the other petitioners here prevailed, and the state's effort to discriminate against aid to religious schools also failed. And it was a long time coming. The decision, you can trace back this decision to, I think, really, a case like Zellman that said that there wasn't an obstacle at the federal level to voucher programs and other school aid programs. And you can also trace it back to a decision that was a plurality decision that was authored by Justice Thomas called Mitchell against Helms, which really was one of the first modern cases to focus on the Blaine amendments and their history of bigotry. And I think those two threads, the thread that started with Zellman and the thread that started with Mitchell, really came together in this decision for the court.
And Paul, the Zellman, just for people to remind them, two quick questions. So Zellman clarifying question, Ohio case. You or George talked a little bit about that. And then the free exercise clause is not a separate clause. It's part of?
It's part of the First Amendment. So critically, and sits right with the Establishment Clause and the Free Speech Clause in the First Amendment to the Constitution. To just say a word about Zellman, I will just, remind the history buffs that back in the Sixth Circuit version of the Zellman case involving a challenge to the Ohio school choice program, I actually authored an amicus brief for the Center for Education Reform back in the day. So, Jeanne mentioned that, kind of my representation of CER goes way back. And indeed, it goes back before the Supreme Court took the Zellman case. In the Zellman case, the court wrestled with the question of whether kind of first generation school choice program was consistent with the Establishment Clause of the federal Constitution, or whether it ran afoul of some earlier cases that said that under the federal Constitution, you can't have direct aid from the government to religious schools. And the court, in a 5-4 decision, critically said that no, these school choice programs and other programs that provide only indirect aid are critically different. And it's not really the state directly funding religious institutions, but it's only the funds from the government only flow to the religious institutions because of the intervening decisions of parents and students. And that's really interesting that if you read Chief Justice Roberts' opinion for the court in the Espinoza decision, he picks up on that thread from the Zellman decision, and in kind of weighing the interests of Kendra Espinoza on the one hand, to send her children to the school of her choice and not be subject to religious discrimination on the one hand, and then balancing that against the interests of Montana in preventing any sort of aid to religion. The court really emphasizes that thread from the Zellman decision, and emphasizes that the state's interest here is pretty attenuated because the state's not preventing its funds going directly to a religious institution. The state is, only has an interest in this sort of indirect funding, and that really isn't much of an interest at the end of the day, certainly when weighed against discrimination on the basis of religion and the federal free exercise clause.
So George, our colleagues, friends, we are longtime admirers of the Institute for Justice that carried this case to the Supreme Court from Montana. Talk to us a little bit about sort of the role of, so what happened in Montana to give everyone context, because then, and you played a critical role in this amicus brief, because then states are going to be basically saying, okay, now what do we do with this? And so I know we have Tim Keller from the Institute of Justice on, and at some point, Tim, I'd love to welcome you to join us for a comment or a question, because you guys were the heavy lifters. We were just the supporting actors. But George, go ahead and tell us a little bit about Montana and why this is important right now.
Sure. Well, I think the first thing to say in response to your question is to absolutely recognize the Institute for Justice and the amazing work that they have done in this case. In similar cases, they really do really great work for, in particular, individual plaintiffs like Kendra Espinoza and the parents here and the children. There's a sort of a niche that can often get overlooked, and the Institute for Justice does great work in representing those types of individuals. And this is a case that came out of Montana in a way that has been teed up in other states as well. And the way it comes about is when a state legislature enacts some sort of You can call it a voucher program, a tax credit program. There's all sorts of different mechanisms by which legislatures essentially are in some way, directly or indirectly, using state funds to allow parents, children, through their parents, to use that money at a non-public school, at a private school, and most of the time, those programs, will allow the parents to use that money at any private school, and that tends to generally include schools that are religiously affiliated or controlled or governed by a church-related board or something along those lines. And that's where, in the last, as these programs have started to take root in the last couple decades, particularly after the Supreme Court in the Zellman case said that doesn't violate the Federal Establishment Clause, where they have then run into obstacles is under state provisions. And there are a number of states, Institute for Justice has all the full stats on it, but I want to say it's somewhere in the 20 to 30 area that have some form of a state prohibition on using state funds directly or indirectly, or even in sort of the most tangential way towards religiously affiliated institutions. And those can be often they're in the actual state constitution. They might actually be, state enacted legislation at some point. There might be a state attorney general opinion. There might be a state Supreme Court decision, either from the last couple of years or maybe from however many decades ago. And what all of these state obstacles are doing is basically saying in some shape or form that that state funds cannot be used for the benefit or the use of any school or teacher, or that there's different ways to formulate it, but that are religiously affiliated or controlled by a church.
Even the independent decision of a parent. That's what sort of those states basically have rested on their laurels. I think it's 37 altogether that have Blaine. Some are less prescriptive, so it's probably in the 30s that are really strict, as you said. But even when a parent, as Paul was saying, George, says, I wanted to go there, and the court has looked at that parent as neutral, those states still have basically said, nope, can't do it, no way, shape, or form can your monies flow to the private school choice. That's
correct. So even when there's that indirect sort of breakage of the causal chain between, this isn't a situation where the state is literally just, writing a check to a religiously affiliated school or a church or something like that. And in fact, a lot of the time in Montana is a situation where there's sort of a double shield, if you want to call it, because in Montana, what they did was the legislation set up scholarship organizations, and people could donate to those organizations, receive, I think, a tax credit or some sort of tax benefit, and then those organizations would give, a check to a parent who made a decision as to where they wanted to use that check for tuition, and it could be at a religiously affiliated school. So there really was almost, two indirect paths between the state funding and the religiously affiliated school. But at the Montana Supreme Court, just as a number of state Supreme Courts have done, and a lot of them have done this in the wake of Zellman, because this was sort of the next obstacle that opponents could use. And so what the Montana Supreme Court did in this particular instance, which is similar to what you've seen in some other states, is to say that, look, we have this state constitutional provision, and and I can try to read it, but it's it's pretty capacious. Yeah. It says, and this is typical of the kind that you see in a number of states: the legislatures, counties, cities, towns, school districts shall not make any direct or indirect appropriation or payment from any public fund or monies for any sectarian purpose or to aid any church, school, academy controlled in whole or in part by any church, sect, or denomination. So it really doesn't get much more expansive than that. And so the Montana Supreme Court took a look at that provision and said, look, this is what, this program is what is not allowed under this state provision. And then it had to, oh, I'm sorry.
No, I don't mean to interrupt you, but George, but here's what's really interesting. It's when I'm listening to and attempting to be objective, and again, we're all kind of giddy who've been wanting to get rid of this barrier to true parents directing the education of their children. But even when I step back and listen to you and Paul describe those amendments, they sound really logical. People like Americans United and teachers unions and other people who are guardians of education go, well, that makes sense there'd be that barrier. But let's look at actually the origins, because that's what's been fascinating to so many of us involved in this, is that people had never heard of a Blaine amendment. Even as we were talking to reporters over these last several months, we're having to explain and re-explain how they got there, and no one really kind of gets that history. I mean, Paul, you want to walk us through the James G. Blaine, like how it wasn't as if the founders stood up one day and said, oh, we have to make sure that no one ever uses money to go to a private school, even if it is a public good.
Yeah, Jeanne, I'd love to talk about that. And it's a fascinating history. And you're right. It was kind of interesting. It was obscured, I think, by the fact that starting in the late 40s, in the Everson decision, and in the 50s and the 60s, the U.S. Supreme Court interpreting the Federal Establishment Clause really, itself erected a pretty high wall of separation. And so that's where all the action was. And then in the Rehnquist court and now in the Roberts court, as that federal wall has come down, as we've talked about, a lot of the movement shifted back to the states and those state constitutional provisions. And when you first looked at them, they didn't seem that crazy, because they seemed a lot like the Supreme Court precedents from the 1960s and early 70s, in that they said, zero aid. They talked about sectarian schools. We had kind of grown up thinking, yeah, sectarian just means religious. And when you actually dig into those amendments, especially the ones that go back all the way to the Blaine era, and most of them do, you realize that, sectarian wasn't some anodyne way of referring to religious schools so that you needed to get a thesaurus out or something. Sectarian was really directed at Catholics and Catholic schools, and the horrible possibility at the time that any federal funding could go to educate Catholic students in their Catholic faith, through public funds. And so, to really understand this history, I mean, now one of the best things to do is read Justice Alito's concurring opinion, and we can talk more about that. But, you really have to rewind the tape almost all the way to about the 1850s. And you had sort of potato famines, potato blights in Ireland and Germany caused a lot of Catholic immigration to the United States. At the point of that wave of Catholic immigration, you had nothing like the wall of separation of church and state that people in our generation are used to. You had public schools that were teaching essentially the Protestant Bible. And these Catholic students came in some places they were concentrated in urban areas, as new immigrants tend to be. And they walked into these public schools with the Protestant teachings and the Protestant Bible. And, some of them said, wait, what's going on here? Especially in this new school district that we're creating, because all this new population, almost all of us are Catholic. Why don't we read from the Catholic Bible instead of reading from the Protestant Bible? And the reaction to that from a certain segment of the Republican Party at the time, led by, Senator Blaine, was that we are going to, really respond to that. And we are going to say, no, that's a threat to our traditional way of life. That is a threat to what we've gotten used to, which is Protestant education in public schools. And so we are going to try to squelch that. And so there was an effort to amend the federal Constitution to prohibit aid to sectarian schools, which meant aid to Catholic schools. And it came very close to passing, but just failed. And when it failed at the federal level, unfortunately, it spread to the states, where it's often much easier to amend a state constitution than it is to amend the federal constitution. You know, one of the many manifestations of the genius of the founding fathers of the United States was that our Constitution is hard to amend, but some of the states make it very easy to amend the constitutions. So in the 1870s and really, you know, all the way through the 20s and 30s, on a wave of, you know, in varying states to varying degrees, but in a wave of anti-Catholic sentiment, these amendments became part of state constitutions. And as I say, they sort of got forgotten a little bit in the 50s and 60s because the action was on the federal level. But you had this in the 80s and through till this decision, really, you had this phenomenon where these amendments that were the product of anti-Catholic bias 100 plus years ago were being used in the present day to discriminate against religion. And, you know, it really took, I think, Justice Thomas's plurality opinion for the court in that Mitchell v. Helms decision I alluded to really start people refocusing on the Blaine amendments. These are not just little innocuous no aid provisions. These are really, you know, religiously discriminatory in their creation and in their application.
I had myself on mute, pardon me. The fascinating thing about those amendments and the context that is a history lesson for anyone watching or anyone who teaches students out there is through sort of the Thomas Nast commercial, you know, the cartoon. So Thomas Nast was this famous cartoonist, and some of you may have seen his cartoons. He's the one who created the donkey and the elephant, by the way, for the political parties. Harper's Weekly carried him. He was vehemently anti-Catholic. He loved Blaine. He used to paint Blaine into his photos of all these very dirty, you know, urchin-looking immigrants. I mean, it's so interesting and so common to, like, it's just so relatable today. So you mentioned Alito. One of his quotes was, "One cannot separate the Blaine Amendment from its context, the founding of the American Common School and the strong nativist movement." And he also said the delegates at Montana's Constitutional Convention in 1972, which revisited the Blaine, right, from the 1800s, acknowledged that the no aid provision was a, quote, badge of bigotry. And one Catholic delegate recalled being let out of school in the 4th grade to erase the KKK on the front doors of the Catholic Church in Billings, Montana. Right? So there's just like no question that this thing was intended to squash one kind of person. And so how ironic it is that it's taken this fight, and that on the, you know, moments after the decision came out, the heads of the national teachers unions called this extreme. It's the death knell of public education, that they would have sided with the James G. Blaine. George, that just seems really inconsistent. So what do we do now? So where do we go? Like, there are a lot of people asking, you know, does this mean that, you know, people can just start enacting educational choice programs? We'll get to the specific Q&A in a minute, but are there other steps that we have to take to eradicate this stain of bigotry on the United States of America?
Well, you know, one positive, well, there are a number of positive things about the majority opinion, but, you know, going specifically to your question, when we were talking about the history of the Blaine amendments and sort of their very sordid genesis, you know, and Justice Alito's concurring opinion goes through all that in great detail, but the majority opinion for the courts, you know, it refers to that, but it actually is sort of an almost broader opinion, because if you could think, if you had an opinion that really just kind of, a majority opinion that really just said, look, you know, these provisions, they come from a really, you know, unpleasant background, and, you know, and that's just not really how we, you know, want to have things acting today. You could then see a situation where perhaps, there would be a way to kind of get around the majority decision by saying, well, a state could say, well, look, our provision isn't like that. Our provision doesn't have, it wasn't born of bigotry. It's not from the 1870s, et cetera, et cetera. But the majority opinion by the Chief Justice, it knocks down the application of these provisions to programs like Montana's without really, it touches on it, but without sort of relying exclusively on the history. And really what it does, and in a way that I think makes it a broadly applicable decision, is it really just says kind of very straightforwardly that, look, if you're going to have a generally available, generally applicable funding program, you can't discriminate on the basis of religious status, period, end of story. So any state that would try to use one of these provisions, or any opponents, I should maybe be more specifically say, would try to use one of these provisions to try to enjoin or simply, just throw up another obstacle to a program like they had in Montana, like other states have, it will not succeed to the extent that it tries to prohibit money from going to religiously affiliated organizations. And then another sort of broader aspect of the decision that I think, again, will give it sort of broadly applicable uses here, is that one of the arguments that was made by the respondents in this particular case was, well, what the Montana Supreme Court ended up doing after it found that this violated the Montana Blaine provision is it struck down the whole program. It just said, look, nobody gets any money, not the religious schools, not the private non-denomination schools. Nobody gets it. And so one of the principal arguments and one of the dissents picks up on this argument is, look, nobody's discriminated against. Everybody's in the same place. Nobody gets any money. And the majority opinion addressed that argument and rejected that argument, saying, look, the only reason that occurred is because you had this antecedent discrimination based on a religious status. And so I think that's another way that it sort of knocks down another argument you could have seen people trying to make, that, okay, well, let's just not have, now you could still not have any religious or any funding program in the first place, but once you do that, you cannot use these provisions, you cannot apply them to simply say that non-denominational schools get the money, but any religiously affiliated school doesn't.
What was the analogy? I don't remember who was using it, or whether we were just talking about the soup. Like if they all can't have soup, one person can't have soup. What was the?
So Jeanne, I think the way we were talking about it is, if basically the state says, look, I can't give any soup to the Catholic kids, so therefore I'm not going to give any soup to any kids. It's, and you could try to say, well, so nobody's being discriminated against, but actually everybody's being discriminated against because of the subset of kids' Catholicism. So the Catholic kids can't have soup because they're Catholic, and the Protestant kids can't have soup because the Catholic kids can't have soup. I mean, it really is just more discrimination, not less. If I just add a couple of quick thoughts to what George said, I think the majority opinion largely defangs the Blaine amendments, but they remain on the books. And I think that sort of, the way I would sort of say is, I don't think the work here is done. And I don't know that people should be entirely complacent about these Blaine amendments just because of this decision. And let me just say three things why I think that's the case. I mean, first, there's still some loose ends in the Chief Justice's opinion. And one of the principal ones is that he had the felt need to say the discrimination here was based on religious status, not potential religious use. And he said that in part to distinguish an earlier case called Locke v. Davey. But, he relied on that distinction, and that's what actually prompted Justice Gorsuch's separate concurring opinion. And so that does leave it open for people to say, well, we can get around the Espinoza case if what we think the religious program is doing or the funding program is doing is allowing for religious use rather than just discriminating on religious status. And as Justice Gorsuch points out, that's a pretty thin distinction. So that's one reason why, if you just wiped out the Blaine Amendment, you would essentially wipe out the debate about whether it's a use or a status discrimination. So that would be one reason to not be completely complacent. A second reason is it's kind of a corollary to what George was saying about, here on the no soup point, that was what the state Supreme Court did. And it basically said, we are going to essentially invalidate the whole program. But what the court doesn't definitively address, and I think is still a problem, is if you imagine a state legislature having a debate, and the question is whether to have a tax credit program or a voucher program. And somebody in the state legislature says, well, we can't really do this because of our state Blaine Amendment. And that causes the state legislature not to enact it. I don't know how you challenge that. That's kind of state legislative inaction. And so I still worry a little bit that the Blaine amendments in the background are going to cause problems that will be harder to address. And then, the third point, and maybe the one that has the most kind of resonance just at this particular moment, is people all over the country right now are reevaluating monuments, sort of evaluating them in light of both history and kind of contemporary reality. And there's a lot to be said for just not leaving these Blaine amendments on the books as a monument to bigotry. So I do think it's kind of an interesting counterpoint to what's going on. Whatever one thinks about these statutes, the statutes aren't themselves the law of the state that can be used to discriminate. The Blaine amendments still have that potential. And so the idea that we should just leave them on the books rather than take the salutary step of removing them from the books, I think is another reason not to be complacent.
Well, I think that's so true, particularly today, and thank you for raising that. I also really appreciate the complacency comment, because I'd argue that in the wake of the Janus decision, for example, that found you cannot compel teachers to belong to and pay for a union, that almost immediately people who want to compel funding of unions went about their very well-funded merry way in states, ensuring that there were other ways to compel people to be part of unions. Now, it did undermine in part their membership, but it was not acted on. And so there is something to be said for people who really truly appreciate not sectarian education, but equal opportunity to schools and education that it's not governed by zip code, to actually act in states. We have a couple of questions, and I think it might be a good time to turn to a few of them about what does this mean for the actual states that have programs, or what are the specific recommended steps? You've talked about not being complacent. You've alluded to there could be advisory opinions, there could be legislation to take it off the books, right? Could a state simply introduce an educational choice program, Paul and George, and say, and allow that to then go to their court if somebody wanted to sue, rather than try to take it off the books first? I remember years ago, somebody in Pennsylvania in the very early days of educational choice saying to then Governor Tom Ridge, oh, we can't possibly introduce a program like that, it's unconstitutional. So a lot of this is people have actually hid behind this unconstitutionality sense. Can it just be unconstitutional? People can enact these programs, I guess, is the question.
So, I mean, I'll start and I'll say, look, if you're thinking about passing a program, particularly a program that's anything like the program at issue in Espinoza, so anything in the sort of, as you say, anything really designed to address sort of the discrimination by zip code, to free people up, whether it's a voucher program, a tax credit program, whatever precise form it takes, I think you would be pretty well positioned to say, in light of Espinoza, we don't have to do anything more. We can just pass our reform, and we can sort of fight it out in the courts. But we should make pretty quick work of the opposition based on the Espinoza decision. I think, though, like I said, I think in a perfect world, you'd want to couple that with something that does target the state Blaine amendment for repeal, not because it's a necessary precondition for education reform after the Espinoza decision, but more because it would be, cleaner, but also, it's just arguably in light of the history that has really been brought to the fore by both the majority opinion, which does allude to it, and Justice Alito's opinion in particular. It does seem like, cleaning those up and, and frankly, forcing people to try to defend them, given their origins, I think would also be a useful idea. But I think, you could have one without the other. I don't think if you're pushing for education reform, you have to wait for the repeal to take place, especially in light of the Espinoza decision.
Yeah, I mean, just to add on that, the challenge in this case, in the Espinoza case, the Institute for Justice legal arguments was not to strike down the Blaine amendment. It was not, what we would call a facial challenge to the amendment, where to say, look, this thing is unconstitutional in every respect, get rid of it. It was, to ensure that as applied to this program, it would not violate the free exercise clause. And so, as Paul was saying, you probably could follow a similar model of setting up your program, waiting for the inevitable lawsuit and defending it based on Espinoza, but also, getting your ducks in a row as to what you think the other arguments are going to be, whether it's, well, hey, this program, we're not saying that the Blaine, our Blaine amendment is discriminating based on religious status. We're saying that we don't want money to be used for religious education, and gosh, there's no real way to separate. When you send money to a religiously affiliated school, there's really no way to separate it out, and so that's fine under Espinoza. I think you have to sort of be prepared for arguments like that, and maybe think about that even in enacting or discussing the possible legislation setting up these programs as to how to maybe preempt arguments like that, where people will say, no, this isn't covered under Espinoza because, my gosh, the schools that these are going to, they reek religious education. There's no way to separate it out.
Great point. So let me start asking Michael maybe to come in and help us address some of these questions. But one that I want to raise that is being brought up a lot. Hi, Michael Musante, how are you?
Hello, everyone.
Executive Vice President of the Center for Education Reform. I'd much rather be seeing, however, a picture of James G. Blaine behind you with like an X in his face rather than but it is home at Zoom time. So so what are the implications, George, for non-sectarian private schools? Are there any? Is it kind of go back to the soup analogy, or are there none really as a result of the Supreme Court decision?
Well, I think that I wouldn't say it's sort of directly as a result of the decision, which really kind of focuses on the religious status aspect of things. But I think that, to the extent that there's that question about, well, either everyone gets it or nobody gets it, to the extent that the private non-sectarian schools would also like there to be these programs, I think that they're also going to have to think about how best to, to sort of shape the mechanisms of these programs so you don't fall into that trap of, well, we're just not going to offer it at all. But I think that, they can take heart in the fact that the majority opinion, knocks some of the legs out from under that argument. So, to the extent that they would be in favor of these programs in general, there is something, they take away a benefit from this decision as well, even though, it's not strictly a religious status thing to them.
Great. Michael?
Yeah, Jeannie, going back to the top of our questions, and this seems like an official legal term. So to Paul and George, whatever happened to the lemon test, both in Zoman and here?
Well,
Is there a
I know.
actually, Paul, though, for those of us in the uninitiated, could you explain what the lemon test is, just in case?
Sure. I was alluding to some of the kind of, high wall of separation cases back from, the 50s, 60s, and early 70s. And, I was being somewhat specific in saying the early 70s because, right around 1973, I might be off by a year or two, but around 73, the court, tried to kind of summarize its Establishment Clause jurisprudence with the, so-called three-pronged Lemon test from a case called Lemon against Kurtzman. And, that test, talked about, the sort of the purpose and effect of the law and entanglement. And, for a while, people who were litigating in the religious liberty space, would, really were, asking the court to try to overrule Lemon. And, really that was a big topic of discussion. And, what really started happening about 15 years ago is that the Lemon test, while never overruled, just sort of became less and less important in Supreme Court decisions. One of my favorite Justice Scalia separate writings was in a case called Lamb's Chapel, where he sort of talked about how, the court, used, he likened it to a ghoul in a cheap horror film that, that it seemed like it was dead and then it would pop back up and scare the children. It's a great read. I highly recommend his opinion. But his point was that the court had sort of developed this very kind of convenient relationship with Lemon. If they wanted to strike something down, all of a sudden they'd start talking about the Lemon test and how it failed the Lemon test. And if they wanted to uphold something, largely they would just ignore the Lemon test. And the point he was making, which I think was a very good one, especially at the time, was, it's all well and good for the Supreme Court, but lower courts, since the court has never overruled it, have to wrestle with the Lemon test. And, litigants and lower courts are spending a lot of time talking about something that actually doesn't necessarily seem that important in the Supreme Court's own decision-making. And so fast forward, that Lamb's Chapel decision was something like 1993. So, fast forward, 25 years. And I think at this point, the Lemon test really just doesn't figure that prominently at all in the Supreme Court decisions. And I think it figures, frankly, prominently less and less in lower court decisions as well, because people have kind of gotten the hint that, you look at it, and Espinoza is a perfect example. In Espinoza, the focus was less on the Lemon test, and the parties were sort of litigating on whether this was more like the Trinity Lutheran case from a few years ago, where the Supreme Court allowed money to flow for safe playgrounds, or was it more like Locke v. Davey? And, the case that said that a state could limit scholarships to study the clergy, for training for the clergy. And, people have stopped just talking about Lemon, which is this abstract test about the Establishment Clause generally, and really focused on more specific case-focused issues like now the Espinoza case, which I think will become, a very important case and will be a full response to anybody who tries to say, well, you can't do this because of Lemon against Kurtzman.
And reading the decisions, reading the everything about it, where they cite all these cases and put them in different contexts, it's a fascinating history. Even if you don't know a lot about it, I'd commend it to anyone as good summer reading. Paul and George, let me throw these two questions out. Michael, if you don't mind me stepping in, because I think they're related. One from Mark Walsh, a court reporter for Ed Week, and another one from Kevin Heft. Can one of you address Justice Breyer's question about charter schools? He seems convinced there are some states that might find this a trigger to obligate funding for religious schools. And then the related question is about Justice Thomas's concurring opinion on the other side that talks about the Establishment clause itself and properly understood how it does not prohibit states from favoring religions. So sort of two sides, Breyer and Thomas.
Well, Ms. Paul, I'll tackle Justice Thomas. I'll leave Justice Breyer for George. You know, on Justice Thomas's opinion, you know, he has articulated this view before, but he has you know, a very originalist view of the Establishment Clause. I think that, you know, he would be the first to concede that his view is not consistent with the view of a majority of the court. But he, you know, the short way to describe his view of the Establishment Clause is it really can't properly be incorporated against states. You know, that really wasn't, it was really just designed to prevent the new federal government from establishing a state national religion. It was, you know, originally designed to allow the states to do essentially whatever they want, including have their own state religion that might be different from a putative national religion. So kind of based on that very originalist understanding of the Establishment Clause, he says, you know, that you know, what has made this area of the law hard is, you know, the search for the so-called play in the joints between the Establishment Clause and the Free Exercise Clause. And his view, which has now been joined by Justice Gorsuch, which is interesting, but his view is essentially there's a lot more play in the joints than people recognize because the Establishment Clause really doesn't have that much of a role to play. And the Free Exercise Clause and its protection against religious discrimination really ought to be what's almost, you know, all but occupying the field here as far as federal constitutional law. I don't think that Justice Thomas is on the verge of getting a majority of the court to adopt his view. You know, I think he doesn't think that either. But, you know, it is very relevant for litigators, especially as they think about cases going all the way to the Supreme Court, that you now have two justices on record as ascribing to that view.
And I'll talk briefly about Justice Breyer's question and his the statement in his dissent about, you know, does this bode a constitutional obligation to fund religious schools? You know, it's frankly the kind of comments that is sort of not unsurprising from Justice Breyer, in the sense of, you know, he's the one who always comes up with the far-reaching hypotheticals to sort of say, you know, well, where's your limiting principle, et cetera, et cetera. You know, I think that it kind of gets back to the discussion we had earlier about, you know, the funding program in the first place, and sort of how is it set up, and, you know, and is it set up, and is there a state court decision that sort of carves it back because of religion? And, you know, I think going forward, and this sort of circles back to what we were talking about in terms of how to sort of legislatively approach these going forward, is you know, is the idea that if you have sort of a generally applicable program, then to carve it back based on you know, religious status would be problematic in light of Espinoza. But I don't think, you know, I think it's and you may see these arguments by people trying to sort of maybe, you know, say, well, we've got a program that gives money to, you know, charter schools or non-sectarian schools, so therefore there must be funding of religious schools. You know, I don't think it's going to map on as well to the majority opinion in this case, which really tries to sort of, you know, keep it within the confines of really like how most of these cases and programs have been established already.
Right, on a program that has provided choices for parents among a wide variety of schools, and having funding flow to those schools by way of the decision of parents. And there's really interesting, a couple of different people in the press have been like, oh, this opens the way for religious charter schools, which, first of all, is kind of a non sequitur. Charter schools are public schools. You don't have to have religion in a charter school, nor is that the intent of a charter school. You want to have a religious institution that is by nature a private school. And even if it wasn't, and you could completely have all sorts of different definitions, the issue is really the scholarship / voucher / tax credit programs that allow parents to make choices about where their tax dollars go should not be prohibited by the citing a Blaine amendment, which is now found to be unconstitutional. Is that right?
Right. I think that's the right way to approach it. And I think, Justice Breyer also talks in his dissent about, this is just going to lead to greater entanglement and, and strife in trying to figure all this out. And it kind of reminds me of there's a great line in going back to the Zellman case, which was the 5-4 decision written by Chief Justice Rehnquist. There was a very similar argument or statement made by one of the dissents in that case. I think it might have been Justice Stevens at the time, and Chief Justice Rehnquist, said in his majority, the only strife or entanglement that seems to be going on here is people bringing litigation. In the real world, it hasn't really kind of come to bear. And I think in the what is it now 20 years since Zellman, I don't think that a lot of people would say that the parade of horribles has come true. Now, in part, that's because of these extra efforts to try to throw up additional roadblocks. But I think that it's if the past is any indication, then the sort of suggestions that it's going to lead to a tidal wave of complete rethinking of how all of these schools are funded, et cetera, is not dissimilar from what was said 20 years ago.
Right. Great. Michael?
Jeanne, we have a question from Samuel Carter. Paul and George, the Chief's focus on religious status versus religious use seems critical. Do we foresee, especially recently supported arguments by the court, putting pressure on choice programs to do de facto, accepting different teachings that might be in direct contrast to their religious mission? Do you see that occurring?
So personally, that's not where I see this kind of distinction going. Where I see the distinction going is, if you take a step back and you think about this from the perspective of opponents of involving religious schools in education reform efforts. And, after Espinoza, what do they have left? They have Locke v. Davey, and they have this sort of use versus status distinction. And so I think those will be, the tools that they have left to try to challenge these programs. I'm not, sure that, the use versus status line is a very stable one. Obviously Justice Gorsuch really focused on this. I thought the way that the majority opinion handled that point was kind of interesting, because it didn't just disagree with Justice Gorsuch. It just sort of said, we understand that criticism, and we just think that this is pretty clearly on the status side of the line. So I don't view that distinction as kind of the entry point to really kind of regulate what the religious schools do. I'm not saying people won't try to do that, but I'm not sure that distinction will necessarily help them. I do think for states that are thinking about expanding their religious, their education reform programs, and I think this was the point that George was making, it's just worth having that distinction in mind so that you don't kind of walk into a problem where, you talk about the funding and your non-discrimination and what you're doing only in terms of use, but you also kind of make clear that what you're avoiding is discrimination on the basis of status.
Right.
And just to pick up on one quick point, about the status versus use, as Paul pointed out, the majority opinion, addresses it. It says we don't really need to get into it too much, gives a nod to Justice Gorsuch, et cetera. If you read Justice Breyer's dissent, which really was kind of the main dissent on the merits, he kind of almost buys into Justice Gorsuch's view, at least sort of in this context, that there really isn't that much of a difference between status and use, because he says, look, like, why are these schools religiously affiliated in the first place? Well, it's because they have a mission and they have a ministry, and that's like the point, is that they are there to, you know, teach religious values to some extent, and you can't really you know, divide that from all the other stuff. And so, you know, he almost, I mean, and that's what his criticism of the majority opinion is. So you know, I think there might be even sort of an opening at some point to say, look, yes, the majority opinion really focused almost exclusively on religious status, but, you know, even the dissents sort of accepted the idea that, you know, status versus use in this context, maybe there's really not that much of a huge distinction at the end of the day.
And that was his big the day of the argument. I remember he kept asking, so wait, if religious schools are there to, he said something that this is the way you educate future generations, is you put them in religious schools. And so therefore he was suggesting that his decision or his thought was around, therefore, if you use money to go to a religious school, the state is advancing religion, since religious schools' primary role is to educate people in the faith, right? And so you could see that coming in the argument in a way. And so it's fascinating how it ends up in the decision. Maybe he had already decided what he was going to decide. Somebody from Michigan has a really interesting question about their Blaine Amendment, which is a fairly, you know, modern version. It's not that modern, but what's the chance of moving a legal argument about the anti-Catholic discriminatory intent in their anti-aid amendment, even if it lacks the explicit sectarian language? In other words, it doesn't have to refer to Catholicism. It's just about funding, right?
Yeah, so I mean, I think that's right, and you know, I'd have to look at the specifics of the Michigan amendment and sort of how it came to be. But you know, the way I would think about this is, okay, look, you know, if instead of using the word sectarian back in the day, they had been more explicit and just said Catholic, and you had all these provisions on the books that said no aid shall go to a Catholic school, like it would have been obvious to everybody at a certain point that that was unconstitutional, and all of those things had to go. So to the extent you have amendments that are out there that, you know, the only difference between that hypothetical no aid to Catholic schools and the current amendment that remains on the books is the reference to sectarian, you know, that shouldn't really make much of a difference, and they shouldn't be any more tolerable. Now, if you're in a state, and apparently Michigan's one of them, where it's not as sort of simple as that, then I think you do have to kind of untangle the history a little bit, and you know, figure out whether, you know, this is an amendment that, you know, somehow, you know, still isn't going to have a lot of practical import in light of Espinoza, but maybe doesn't share some of the kind of historical analogs, or whether it's just a slightly more complicated argument, but you really sort of trace it back, you know, and I wouldn't be surprised if at least in some states, that an amendment that's on the books that looks a little bit different than the classic little Blaine amendment is just one standard deviation removed, that maybe, you know, if you went to the history of the Constitutional Convention that adopted it, that they, you know, borrowed it from another state that had a Blaine amendment and they just tweaked it a little bit and not in a way that's really material, in which case I think there would still be, you know, a pretty strong argument. So I don't think, you know, just because a particular state's constitution doesn't use, you know, magic words, I don't know that that's enough to say that, you know, it doesn't have this sort of taint. But on the other hand, you know, if you don't have the magic words, then you probably do have to do a little more digging.
Well, taking the current day analogy used before, Paul, about, you know, statues, that's like saying that my city put up a statue to Robert E. Lee because he was a good father, versus some other city put up one because he liked the Confederacy. So what, you protect one at the expense of the other? No, it's a bad thing, period, if you think it's a bad thing. So I agree with you. I think, yeah, maybe you have to parse through it, but this opens up the pathway for them to do that, right?
Yeah, no, I think that's right. And again, I think, going back to Mitchell v. Helms, which has now been embraced by a majority of the court, you do have this recognition that, sectarian is kind of, not the innocuous word that maybe some of us, grew up thinking that it's just, useful shorthand, sectarian, non-sectarian, that it really, in many of these amendments had a different meaning, but I don't think that's the sum total. So I don't think that if you just don't see the word sectarian in your state constitution, that's not a reason to not to continue to do some digging.
Yeah, and just
go ahead, George, sorry.
quickly add on that, the Chief Justice's majority opinion, when it gets into the history, he does an interesting thing with it. He notes all of that, the sort of the sordid genesis of a lot of these amendments, et cetera. But he does it in a section where what he's doing is he's refuting the other side's reliance on the Locke v. Davey opinion. And what the court had done in Locke v. Davey was it said one of the reasons we're not going or we're going to allow Washington State to, forbid the use of money for sort of training of clergy or ministry degrees is because there is a very well-established history of not funding ministry degrees and ministers and theology degrees, et cetera. And he said, we don't have that here. And that was what allowed, so he sort of put the burden on the opponents to say, look, where is your well-established history of not funding religiously affiliated schools? He said, not only does that not exist because, at the founding and in the 100 years afterwards, there was plenty of funding for religiously affiliated schools. They were all generally sort of Protestant. But he said, and that's when he was able to tie in all of the sort of sordid aspects of these no aid provisions. And so I think in the way that he approached that, he made it possible for even in states where there isn't the direct lineage to these little Blaine amendments and the late 19th century, that's not going to get you out of the bailiwick of this majority opinion, because you had to show a lot more, and the opponents in Espinoza didn't do it, and I don't think that the opponents in other states would do it either.
Great point.
And we had a follow up to the thing that Michigan says no money to all private schools, religious or not, and there were a number of people who were throwing out in Salt Lake City. It doesn't seem to be Catholic, but other religions who we are well aware of who makes their base in Utah. So I guess the next steps are, and I think we lost Tim Keller from IJ, but Paul and George, what can we had a state legislator reach out. She's a first-time legislator. What can state legislators do then to remove the Blaine Amendment? I know that answer really depends on individual states, but just, is it a joint resolution? Do they have to strike it by a piece of legislation that then has to be passed by both houses, House and Senate, and passed to their governor? Can the governor execute an executive order? Can the attorney general? What would your advice be in general for most states to rid themselves of their Blaine amendments?
Well, I can take a first crack at this. A lot of these amendments are in state constitutions. And kind of getting back to the history, a lot of these states were, in fact, required to include them in their state constitutions as a condition of being admitted to the union. So, that is, I know you asked sort of what can they generally do, and I hate to say, it depends on the state, but to the extent that some of these provisions are in state constitutions, then, there's going to have to be, at least at the end of the day, a process followed to kind of excise it or to repeal it from the state constitution. Now, I think that certainly, even if you have that sort of situation, you can kind of build momentum for it by getting all of the building blocks in place, whether it's a legislative resolution or attorney general opinion saying, look, in the opinion of the state or the attorney general, this just, because it was born of bigotry, and even if it was readopted in 1950. That doesn't remove the stain. See Ramos v. Louisiana, another recent Supreme Court decision.
I just want to, I want to just stop you there. But if you have, if you have a decision on the books, as we do, that says this is a violation of the Establishment Clause, couldn't a state issue an opinion or enact legislation citing that? And then if and when it would go to a court, then the court has an Espinoza decision rather than having to go through a constitutional amendment process. I mean, this is what people who don't like this decision would like people to believe, is that you have to suddenly amend your constitution. Are you saying that, are you saying that? Or are you saying that you can actually still nullify it with advisory opinions, legislation, et cetera?
I mean, I think I was saying more, and this is if the end goal here is to literally get it off the books, that you'd have to, go through more.
To just nullify the effect. And it can sit on the books, but be basically mute. Right?
Well, I think, I mean, and if Paul has a different view, he might, but I think that it kind of goes back to what we may have been discussing earlier, which is, you can have your program and then sort of wait for the challenge, or if you have a program, or you could even have an attorney general opinion ahead of time that says, look, if we were to enact a program that has XYZ elements, it's the opinion of the attorney general that provisions A, B, and C in the state constitution will not have this effect on it because of the Espinoza decision, et cetera, et cetera. I think you could certainly, build that into the process so that you're kind of preemptively addressing and refuting arguments that might come up in actual litigation.
Yeah, just to amplify that point, I mean, I think if there's really kind of two things you need to untangle. If your primary interest is, education reform and passing new legislation in the education reform space, then the good news is I don't think there's any need to, as a prerequisite, repeal your state Blaine amendment, or really, even get an AG opinion or anything, because, Espinoza ought to give you the green light that you need to have education reform, notwithstanding that there's still this state Blaine amendment. On the other hand, if, and George, I think, was making this point, if your primary target is not just education reform, but is actually to get this amendment born of bigotry off of your books, then I think you do have to go through, the process. And, I think people, some people are going to want to pursue one and not the other. Some are going to want to pursue both. But probably, the most important message for those that have an interest in getting, education reform on the books that had previously been blocked in part by, references to the state Blaine amendment in that state. There is no requirement that you do anything to the Blaine amendment first. You can go full speed ahead on education reform.
Got it.
And then for those that, have sort of want to get the Blaine amendment off of the books, which I think, there's certainly a case for there being an independent reason to want to do that. They have to sort of go the potentially more arduous route. But, as I alluded to earlier, one of the reasons you got state Blaine amendments and not a federal Blaine amendment is it generally is a little easier to amend a state constitution compared to the process in the federal government. So it may not be quite as high a burden as, some people think.
Yeah, I don't know how most states do it, but I would think that it seems that some states, all you got to do is sort of get a popular referendum, and and that's pretty much all it takes. So this if sort of messaged appropriately and advocated, it seems like the kind of thing that could have some momentum.
And I think we had a comment from a former state legislator in New Hampshire who said to remove a state constitutional amendment, you have to have a constitutional amendment to do that. But New Hampshire also has a tax credit program. So he balancing sort of the differences between those two points.
Quoting Paul, that you actually don't need to remove it from the books to have an education program. If you want to remove Blaine, you have to remove Blaine, but you don't need to remove it to have a program.
Correct.
That's important clarification that has to be made.
And then, gentlemen, for the last question, we have an interesting one that goes back to charter schools. Charter schools are called public schools in most state laws, but the courts have not settled the question of whether charter schools are public or private, whether they are state actors. Some have suggested they may be better regarded as non-state actors. Are you of an opinion either way there?
So not to give a cop-out answer, but I think it might depend on the details of the state law and how they're structured. I think the one thing I would say is I think that's a very important question. It's not a question that is going to be important only for purposes of the religion clauses, but also kind of more broadly. Because, obviously if you're a state actor, then, you're a state actor for constitutional purposes, and that can have implications for everything from the free speech clause to the Fourth Amendment, school locker searches and all of that. So, if you set up the charter schools in a way that they are going to be considered sort of full-blown public schools, state actors, all of that kind of constitutional provisions are going to come with it, not just the religion clauses. And I think conversely, certainly there's nothing, and this is why, I have to give a version of a cop-out answer is, there's nothing a priori about a charter school. I mean, you could certainly set up something in a state that you called the charter school that would still leave the participating schools as, more private than public for purposes of the state actors. I think the way that most of them are set up, as Jeanne was alluding to, and I certainly defer to Jeanne's expertise on this, but I think the way most of them are set up, they're probably set up where it's going to be easier to say they're a state actor than a non-state actor. But I guess the one thing I would say is, that's going to have some implications for what we're talking about, but it's going to have implications way beyond that in terms of whether the whole scope of the Constitution applies to those schools as a state actor.
And I'd be remiss if I didn't end with one other final, somewhat personal question on behalf of CER. But it is important, I think, for people to understand that advocates and groups working in and around policy have a role to play even when it comes to courts and legal context. So Paul and George, who did a fantastic job filing our amicus brief, pointed out to us that the amicus brief was cited. And probably more than cited, we know through some of the language that it was utilized. And so we made a lot of arguments that were complementary. We made some new arguments that were not in other briefs. Paul, do you mind kind of sharing what you think about the value of us having done that in terms of the court's attention?
Yeah, well, so, I think that in a case like this, where there are going to be lots of amicus briefs on both sides of the case, it's fair to wonder, how much of a difference is kind of one additional brief going to make. And, I think it's certainly going to depend. If all a brief does is make the same arguments that a whole bunch of other amicus briefs and the parties have made, then, it may be cathartic to file the amicus brief, but it's not going to make much difference. And one of the things that we tried to do, with the leadership and input of both Jeanne and Michael was to make this a unique contribution, where we made arguments that were similar to the parties but complementary, and really relied on some historical material that wasn't trod by every other litigant. We also had some kind of, everything from brain science to educational theory. And I think that, unique perspective, made a difference. And, sometimes you're kind of left to guess. And here it was very gratifying that we didn't have to guess, because at least in Justice Alito's opinion, there were, two kind of, citations of our brief, one along with some other amicus briefs, another a point that really just we made, and it was a detailed point about the reality that in public schools what they were teaching at the time of the Blaine amendments was kind of a watered down, lowest common denominator view of Protestantism. And, that was something that Justice Alito specifically relied on. So it's obviously great to get that kind of positive kind of reaffirmation. And, and I think that, one other thing that struck me is in the other place Justice Alito cited our amicus brief, he made a specific point of saying that, many of the amicus briefs filed taking issue with the Blaine Amendment were not being filed just by Catholic organizations. And, obviously that describes, CER and its mission, which is education focused. And, I think that just shows that, there can be really real value to these amicus briefs, but only when they're done thoughtfully and only when they're done in a way that's not duplicative. And, this was just a great opportunity to work with, with CER and to work, together with you all. And, I think we produced a brief that made a difference, which is great.
Well, and thank you for that. And collectively, and again, with standing behind our colleagues at the Institute for Justice, there was a huge victory for educational opportunity. And I would just encourage everyone who is part of this today and who has constituents, if you will, parents, students, friends, colleagues, to recognize that it's still a long haul battle, and that whether it be policy-centric or court-centric, that you have to be involved, or we're just not going to make the headway that's necessary for every child to have the opportunity that their parents help direct, which is essential to this. So I thank you. We will be sharing a lot more on email and on social media in the coming days, weeks, probably months. And if you want and need more information, we're happy to connect you with the people who can do that. Paul and George, again, thank you so much for your contribution to the effort and to this event today, and wish you all a great rest of your Tuesday. Thank you.
Our pleasure. Thanks a lot.